All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We are here for oral argument in our case number 180358, Rep. Custom v. McBride. Counsel, each side has 20 minutes for your argument. The appellant may reserve time for rebuttal, but if you do so, please keep track yourself. There's a clock on the podium. The proceedings are being audio and video recorded, so please introduce yourself and your client when you begin. We have read the briefs, discussed the case, so if you could please keep that in mind when you make your arguments. With that, counsel, you may begin.
Thank you. May it please the court, counsel. My name is Scott Zerlot. I'm an attorney with the law firm Sherrall, McGoldrick, Brinkman. I filed a notice of appearance in this case a couple of weeks ago. Mr. Fink, the lead counsel for the appellant, REP, which is my client as well, apparently is in trial or was scheduled to be in trial and asked me to argue the appeal for him. And so here I am. I'd like to reserve 7 minutes for rebuttal. It's clear that REP and the underlying plaintiffs, the Wiles, did not strictly comply with the PDA, the Purchase Dwelling Action Act, in the sense that there was no PDA notice sent by certified mail, no response in writing sent by certified mail, and the like. But the purpose of the PDA fundamentally is to give notice to builders and to subcontractors of defect claims in sufficient time to allow them to attempt to remediate the problems that a dwelling owner has with the construction, and to attempt to resolve a dispute without the need for litigation. And that purpose was achieved, or it was attempted to be achieved. It was certainly met in this case.
But what do you make of the very specific time frames in the PDA for resolving those types of issues, with the 30-day, and specifically talking about tolling a statute of repose?
Right. Well, I mean, those time frames are, by the terms of the statute, allowed to be modified by agreement. And
but by written agreement between the parties. And is there's no evidence of a written agreement on the parties here?
I'm unaware of any written agreement specifically addressing tolling, extending deadlines, anything of the like. I don't believe that there is one.
So what's your best argument for tolling then? It's just that there were some good faith discussions going on, but what if those good faith discussions go on for 3 years? Doesn't that sort of circumvent the whole purpose of the statute of repose?
Well, the purpose of the statute of repose is to protect the defendant, the builder, primarily. And that was achieved because he is informed of the suit, or informed of the claims.
You're saying it doesn't protect subcontractors?
Well, it does, but they also received notice of the defects in this case. They were aware of what was going on, so this lawsuit did not come as a surprise to McBride. My best argument with respect to your example, the 3 years, is if they followed the statute strictly, they could have continued it for that period of time. So there's no reason for them to not have been able to do so more informally, as long as everybody is aware of what's going on.
So you think there's the requirement that there be an agreement in writing to extend the deadlines? That seems pretty specific.
It is very specific, but again, I think that the purpose of that requirement is to protect the builder, to make sure there's no dispute regarding the nature of the defect claims and
but here the builder an action was brought against the builder within the 8-year period.
Correct.
And you didn't think the builder, your client, wouldn't have had a defense? You don't think then if they had waited an extra month and gone beyond the 8 years?
Well, I frankly, it's hard to prognosticate what would have happened under those circumstances. If the builder is genuine, and I have no reason to believe that it's not, when it takes the position that we thought we had a deal that would basically allow us to continue to negotiate, would toll deadlines, then yeah, they would be unable to assert the defense of statute of repose themselves. I think that they could have.
But then they can bind every subcontractor just indefinitely without anything in writing and without the subcontractor being involved in anything.
Well, I mean, technically, I believe the version of the statute that was in effect at the time, the PDA statute, would have allowed them to do that formally anyhow. I mean, there wasn't any requirement to provide notice to the subcontractor of the claim between the owner and the builder. So the subcontractor could have been kept in the dark anyhow. In this case, the subcontractor was not. He was notified in the shortly after, several years before the statute of repose expired.
But you agree it's an exception that the statute of repose just generally imposes this 8-year requirement, and so it's an exception, and you're just saying you can meet the exception even if you don't technically comply with it?
Yes. That's what I'm saying, Your Honor. That's our argument. Another argument that the builder asserts is that the indemnity agreement, which is the fundamental basis of the claim.
Before you leave that one, sorry, doesn't it also contemplate that there's an effort to take care of the problem? Was there anything like that with these negotiations, or what was happening between the builder and the homeowner?
Well, the record's not particularly clear on that, but it does, in my mind, suggest that there was some effort to clear up the issues.
But isn't there's contemplated like a notice of intent to repair? Was anything like that ever sent? Look, we are going to take care of this. There's a notice of intent to repair. It seems very specific, this tolling provision.
Well, my understanding is that was all done informally and verbally. REP went to the project, inspected it along with the owners, noted some problems, made some recommendations, made some repairs, is my understanding, and then informally agreed to just sit on it and wait and see what happened. One of the issues was settlement of the foundation, and so there's a potential that there would be exacerbated damages or some increased damages or additional damages. And the notion at that time was just to see what happens, then we'll try to get it figured out. The homeowners, several years later, hired Ramjack, which is a company that goes in and essentially shores up foundations, who did an inspection. And my understanding is that was part of the negotiation process between the builder and the owners, and that information was also shared with McBride, which is the subcontractor responsible for preparing the pad. So my understanding is there were some efforts to get this clarified, the extent of which isn't clear from the record, but I think that's a fact question that perhaps the jury should have answered instead of the Superior Court. All of this presupposes that the statute of repose even applies to the indemnity agreement. The argument that the builder makes is that this indemnity agreement is separate from the subcontract and isn't itself technically a construction agreement subject to the PDA. It doesn't impose any...
No, they reference each other. You're saying it's just a completely independent document that we can't connect to the
They connect.
contract.
I'm trying to think of a good adjective, but the connection is tangential. Like, I wouldn't say it's tenuous. That would be too strong of a word, I think, but more tangential. And it is a separate agreement that doesn't impose any standards or obligations regarding construction, but simply imposes a duty to indemnify that frankly might not have anything to do with construction itself. It might involve some other sort of liability unrelated to construction that might be imposed upon the builder because of the subcontractor's conduct.
That's not an issue here, though, right?
That's not an issue here.
Indemnification for construction problems.
Yes, we're talking about indemnification for construction. But if it is a separate agreement, as the builder argues, then it's not subject to the statute of repose. It's just subject to the statute of limitations applicable to a breach of an indemnity agreement, which hadn't yet expired. And the third argument that the builder asserts is that the application of the statute of repose in this context is just patently unfair, so unfair that it violates due process. It's tough to convince, it's impossible to convince a court of appeals to overrule the Supreme Court, but the issue needs to be preserved. Although at the time that the briefs were prepared, I don't think that the legislature hadn't yet enacted the amendment to the PDA, which kind of makes the issue moot for the future in the sense that it adds, I believe, 9 months to the statute of repose following the filing of a complaint by the owner. So the amendments currently now, which I believe go in effect very shortly, June of this year, and recognizes the gross unfairness to builders when they face the potential of the complaint being filed the eve of the expiration of the statute of repose and not having time to determine who they need to.
But here there was a discussion years earlier about the requirement that McBride provide indemnification, and they were aware that that was not that had not been done. What's the inherent unfairness in saying you had a couple of years, you had several years within which to file something? That would have been within the 8-year period if it's tied to the contract. And what prevented your client from pursuing that?
Candidly, I haven't analyzed the indemnity agreement for that specific issue, but it may be that the indemnity agreement only indemnified for liability and a duty to defend a lawsuit.
But that's the whole point of why we're here, that they were, the McBride's insurance company said, no, you're not covered. And your client had said, McBride, you're supposed to ensure that you're supposed to make us an insured under your contract. And that wasn't done, and they were aware of that several years earlier.
Right. Well, that, my understanding, that claim was asserted, was dismissed by the Superior Court for whatever reason. I didn't analyze it for purposes of this hearing because I don't think it was an issue raised in the appeal. The Superior Court's denial of REP's motion for summary judgment asserting breach of contract, the obligation to procure insurance. But until there's something to insure and indemnify, I don't think there can be a breach of that duty.
Why did they contact McBride, though, and say, we need you to contact your insurer? There's a problem with this house. And that was several years before the 8 years are up. My
understanding is that they did do that. And
I'm saying then they learned that McBride had not done what they had agreed to do. So why not? I'm just going to your point about the new amendment makes it so it's a little bit easier. You've got 9 months after litigation. But here you had a lot more than 9 months when you found out that there was an issue with providing insurance coverage.
Right. Well, I'm speculating here, but based on my own experience handling these sorts of claims, it may be that you just don't want to get involved in peripheral litigation until it's absolutely necessary. In this case, it created this problem that we're here dealing with. That's the reality of construction defect litigation and the complexities of insurance and indemnity. But
Counsel, is there a difference between the statute of repose and the statute of limitations?
Well, yes. There's several differences.
How about the starting gun?
Well, the starting gun, it's the accrual of a claim. It starts at the same. Well, I take that back. The statute of repose actually begins to run on the date of substantial completion, whereas the statute of limitations begins to run on the date the cause of action actually accrues.
So the statute of repose doesn't have any sort of discovery component that would factor in equity or fairness?
No, my understanding is that case law actually has established that there is no equitable tolling other than perhaps for fraud and concealment.
Why is that?
Well, the courts have decided or have held that the statute of repose is, for the most part, a drop-dead date. But the PDA provides an exception to that, and we're trying to slide in under that exception. But the policy is to cut off litigation at the expiration of the statute of repose.
So, so notions or arguments of equity and we your client would have to wait until an indemnity is ripe, and it just doesn't all happen necessarily in time. That's not really for us to consider at all. Unless you have this PDA, the formal requirements and the notions of equity, unlike the statute of limitations and the discovery gloss, they have no place here, do they?
Well, I don't believe that they do, with the possible exception of there being such a gross unfairness in the application of the statute of repose under the facts of the case to where it violates due process. Other than that, no. I have less than 5 minutes for my rebuttal, so unless you have any questions, I'll sit down. Thank you.
Thank you, counsel.
Good morning, Your Honors, Counsel. My name is Diane Bornshore, and I represent McBride Excavating. As you know, REP has made a large number of arguments in its appeal brief. I want to start off by focusing on the argument that was actually made in response to the summary judgment motion at issue. Since the time that the summary judgment motion was briefed, REP has thrown McBride a lot of curveballs in terms of the substance of its arguments and the procedural issues. We went to the oral argument on the motion for summary judgment, and counsel apparently thought of a bunch of new arguments it hadn't made in its briefing. We objected to those. And then thereafter, after it filed its notice of appeal, after the court had ruled in our favor, and it started filing motions back with the trial court, trying to get the court to reconsider its summary judgment ruling, even though the matter was before the Court of Appeals. One of those motions was actually not filed with the court. It was just served on McBride, which prompted a flurry of briefing, confused everybody. So there's a lot of crazy confusion in this case. I just want to step back and talk about what was actually in front of the trial court when the argument was being made. So there was no dispute that the third-party complaint was not filed within the repose period. That period expired 8 years after substantial completion, and the third-party complaint was not filed until more than 2 months after the expiration of the statute of repose. REP came back in its response to the summary judgment motion and argued that it had been participating in the repair and replacement process under the Purchaser Dwelling Act, or the PDA, I'll call it. They said that the statute of repose was tolled. Well, that came as a real surprise to us. That issue had never been raised before. There had been no allegation that REP and the homeowner had ever engaged in the repair and replacement costs. And in fact, in the homeowner's complaint against REP, the homeowners had admitted that they'd never filed a notice under the PDA. And we had spoken with REP's attorneys on multiple occasions, even before the lawsuit was filed, saying, hey, we think the statute of repose is run. You're not going to file a third-party complaint, are you? There was a mediation that took place before the summary judgment motion. We talked about the statute of repose extensively. Not once were we told, hey, you guys are confused. We were in the repair and replacement process, and this is tolled. That never came up until the response for the summary judgment motion. So the PDA provides that during...
That wouldn't be an impediment if they actually could show that they were involved in the, process.
I
That
agree.
doesn't really matter.
I'm just saying this is just an example of just new things being thrown at us. During the repair and replacement process and for 30 days thereafter, this is the way the statute read, the statute of repose is tolled as to all construction professionals involved for, and this is a quote, the defects described in reasonable detail in the written notice. And that's significant because there was no written notice. Nonetheless,
Is there a requirement that the notice be sent to every subcontractor?
Not in the statute as written at that time. It was only between the builder and the homeowner. So REP argued, you're being too hyper-technical about this thing.
So you went through a mediation?
Yes.
And how did that start? Was there a document filed?
The parties had agreed as part of the scheduling order that they would mediate, and we did a private mediation.
As part of I thought you said you were talking about that. Oh, you're saying after the litigation, not before the litigation.
No, during the litigation, prior to the summary judgment motion being filed, there was a mediation.
Any discussion before the litigation?
Well,
As to, like, why are you guys suing the repose period?
Yes, before the litigation, I had contacted the attorney who was handling it for REP at the time. It was Mr. Shopik. And I let him know, like, we just checked the docket, and the statute of repose has expired, and we see no complaint. So I'm assuming you're not bringing one. And he said, no, we're bringing one. But he did not tell me that he thought that the statute was told.
But you didn't have a discussion before the statute of repose had lapsed?
No. Okay, so as we talked about before, the legislature has set forth very specific steps and procedures. And with regard to each step and procedure, there's a timeline that applies. And it's really important to remember that there are two competing interests that have to be considered here. One is the policy under the PDA, and that statute is designed to encourage early resolution of claims by offers of repair or replacement or offers of compensation. As mentioned in the prior argument here, there's no evidence in the record that REP ever made any type of offer, an offer to repair, an offer to replace, or a monetary offer. They didn't do that at all, and they did not follow the timeline or the procedures. The other interest that needs to be considered is the interest that is set forth by the statute of repose. And that statute was intended to end what the legislature had called the previous indeterminable period of liability for contractors, and to provide a date certain.
Was your client a contractor?
A subcontractor, yes. Mm-hmm.
Is there a difference?
No, not under the way that contractors are defined under the statute. It includes all construction professionals.
So when the legislature said that, who said that?
I'm sorry. The court, Albano Court, Arizona Supreme Court, in discussing the policy behind the statute of repose, said that the purpose was to end the period of indeterminable liability. Yes.
But they meant subcontractors as well.
That's the way the statute reads. It includes all professionals who work on the project. So that the legislator created a substantive right for contractors. It is essentially a grant of immunity after a certain date. And so the tolling provision under the PDA represents the legislature's weighing and balancing of those two competing interests. And that's why those timelines are really important, because the legislature is trying not to go back to that period of endless liability for contractors. It's trying to weigh and balance the two competing interests. And the Arizona Supreme Court in Albano has said that if tolling is to be applied, the weighing and balancing that goes into that is a legislative task. It's not a judicial one. This is a statute of repose that creates a substantive right. So that this is different than a situation with tolling for a statute of limitations. That's procedural in nature. And in that circumstance, it's very legitimate for the courts to consider fairness issues. But what REP is trying to do is just say, hey, we can ignore the very express and plain terms of the statute, but we can still try to enforce the tolling provision against McBride. It can't do that. Per the statute of repose, 8 years expired, the claim is gone, it was extinguished, it cannot be revived. Unless we feel too sorry for REP, it did have defenses it could have asserted. It could have moved for dismissal based on the homeowner's failure to comply with the PDA. For whatever reason, it chose not to do that. And so now we get into the appeal brief, where all these new arguments are being raised.
Saying they could have moved to dismiss, the homeowner filed within the 8-year period.
It had not complied with the PDA by filing a notice that they could have sought dismissal on that basis.
You can dismiss even though you can't just file, the homeowner can't file a lawsuit without going through the
No,
PDA? Okay.
it's subject to dismissal. So in the appeal brief, REP argued something that it did not argue in responding to the summary judgment motion, and that's that the statute of repose, as applied here, impaired the obligations of its contract with McBride. Now, it just threw that allegation out. There's no analysis in there. By the time we get to the reply brief, there's a whole new argument. Now it's that the statute, as applied, deprives it of due process. Again, something just thrown out, no analysis. It also argues, for the very first time in this appeal, that while the homeowner's complaint against it was filed within the repose period, it wasn't served with the complaint until after the statute had run, so that it had no reasonable opportunity to bring claims against McBride. I'm going to say, first off, these arguments weren't made, they were waived. While this court may consider arguments that are new, generally that's done where it's an issue of statewide importance, something that's likely to recur again. As mentioned by other counsel, the statute has since been amended, it's been completely revamped. Now, in the future, subs are going to be part of the PDA process. The time for filing claims has been extended. This is not an issue likely to recur. It's not something the court needs to weigh in on, specifically because it wasn't raised in a timely manner anyway. But REP does acknowledge that no court in Arizona has found the statute of repose to be unconstitutional as applied to subs. There's a tendency to talk about statutes of limitations and statutes of repose like they're the same thing. But the distinction in this constitutional context is very significant. The difference is talked about to some extent in the Albano case, the Arizona Supreme Court case. Also, Denochi versus Neff, which is a Ninth Circuit bankruptcy appellate case that we cited. REP, in its briefing, relied upon 2 Minnesota cases for some language that it thought was rather convincing, and those were the Brink and the Calder cases. We submitted a supplement where we cited another case from that same jurisdiction, Minnesota. It's a later decided case. It's a Supreme Court case. It specifically talks about that Calder case and the language that they were relying upon and explains why it was kind of loose language and it was dicta. The issue in that case was almost exactly like the issue in this case, and that was that the application of the statute of repose to claims of contribution and indemnity that didn't accrue prior to the expiration of the repose period did not violate the due process or remedy clause of their state constitution. And that was even though the different repose period for injury claims made it possible that the injury claim could be timely, but the claims for contribution and indemnity would not be timely. And the court said the legislature could have but did not make that distinction. The same is the case in this situation. And with regard to the statute of repose, statute of limitations distinction, the court said this: because statutes of limitation are procedural in nature, intended to deny a remedy even though a right has been vested, they typically are not triggered until the cause of action has accrued. For this reason, one focus of a constitutional challenge to a statute of limitations is whether it allows a reasonable time after the cause of action accrues for the party to enforce their rights. But for a statute of repose, it's intended to eliminate the cause of action. So most jurisdictions that have looked at the issue have held that a statute may constitutionally eliminate the claim even if it hasn't accrued yet. And the Albano case contains such language also. And the court says the statute of repose doesn't bar the courts to a person with a valid cause of action. Instead, it modifies the common law so that there is no such cause of action. In the context of looking at a contract cause violation argument, the Court of Appeals in the Robeson Ranch case has said that a substantial impairment may be justified if there's a significant and legitimate purpose behind the law. And as we discussed before, there is a legitimate purpose behind the statute of repose, and that was that intention to draw a line in the sand whereby a contractor could look at that date and say, I don't have to worry about this work that I did way, way long ago. I'm not going to get sued for that. And in terms of a substantial impairment, I don't think there's one of those either, because you look at what the parties' reasonable expectations were. And here, REP and McBride, when they entered into the contract, knew what that statute of repose was. That statute was in effect. They knew how long McBride would be on the hook. REP tells us that they had been in communication with the homeowners for years, since 2010. There's some minor issues that arose at that point. Gradually over the years, more issues came up. They knew that a claim was very likely to be filed. They should have known the date by which it had to be filed, and they should have been on top of when it needed to file a claim against McBride to preserve one. The purpose of the statute is to end that endless liability. There was a significant purpose, and there was no substantial impairment. It's not unconstitutional. The other argument that you're not going to find in REP's response to its summary judgment motion is the argument now made about the agreement between the parties not being a construction contract within the meaning of the statute. The gist of that argument is that the contract between the parties says stuff about indemnity, when McBride will be responsible to indemnify, what its insurance obligations are. It doesn't say anything specifically about what the scope of work is. And according to REP, that means it's not a construction contract. It doesn't cite any authority in support of that argument. And in fact, the authority is to the contrary. The statute defines an action based in contract as including an action based on a construction agreement. And the Arizona Supreme Court in the City of Phoenix versus Glen Eyre found that this language should be interpreted to mean agreements made with the purpose or object of construction services. And in that particular case, the indemnity provision at issue there came from a city code related to the issuance of permits, not a contract. That a party obtained a permit didn't mean it was getting a contract. The ordinance did not create a relationship. Here, the agreement that we're talking about is the agreement upon which, McBride was sued on every claim for indemnity, breach of contract, everything. It's the agreement that governed the parties' work on that project. It was entered into on the same date that REP entered into its contract with the homeowners. It was for this particular project, not for any other reason. This was not some general indemnity agreement that generals sometimes have with subs that just relate to its work on any old project. This pertained to this project. Even REP has referred to that agreement multiple times throughout the papers as the subcontract. And the contract itself expressly states that the indemnity provision survives completion of this subcontract. It's the agreement for construction services. So for all of these reasons that we've discussed and the reasons discussed in the brief, McBride urges the court to affirm the trial court's decision granting summary judgment to McBride. Thank you.
Thank you, counsel.
Your Honors, actually, she touched on it, and I'd like to come back to something that Judge Gattani asked me about, and it was, couldn't REP have filed a motion to dismiss the Wiles complaint for the statute of repose? And counsel also pointed out that there is a subsection to the PDA, it's section 12-1363N, subsection N, which went in effect in 2015, which wasn't in effect. This provision, sub-provision, wasn't in effect prior to then. But it allows a builder to move to dismiss the plaintiff's claim if they fail to comply with the PDA. And that's significant in our favor, I believe, because it shows that REP believed that it had an agreement to toll the statute of repose with the owner. Otherwise, it would have invoked its right under that subsection. Counsel also pointed out that the PDA provides for tolling specific to the defects described in the PDA notice. And that's a correct statement of what the PDA says. And we don't have a formal PDA notice in this case. What REP provided to McBride was the Ramjack report, which very clearly articulates the defects attributable to McBride's work preparing the pad. And that was in August of 2013. Finally, our interpretation, which would allow tolling under the circumstances of this case, isn't going to involve endless litigation. At the very least, the statute of limitations would begin to run when there was a breach of the duty to indemnify, which actually kind of highlights the distinction, again, Judge Catani kind of touched on, between indemnity and insurance. The breach of the insurer's obligation to to insure, provide a defense and indemnity, arguably accrued at the time that it rejected the tender. And that was well in advance of the statute of repose having expired.
Wasn't the breach at the time of the construction contract, the initial agreement?
Well, that would have been
by not putting them on the insurance policy?
I'm sorry, Your Honor. That would have been McBride's breach of the obligation to procure insurance. I was referring more to a breach of the duty to insure, which was McBride's insurance company's obligation. That would have accrued when it denied the tender. You're right, the duty to provide the insurance was breached at the time of the contract. But that's different from the duty to indemnify, the contractual indemnity agreement, which doesn't accrue until there's a liability to indemnify and there's no indemnity being provided. And so the statute of limitations of that claim wouldn't have begun running until essentially REP paid something. So that's the distinction between the insurance and the indemnity. I don't have anything else to add unless Your Honors have a question for me.
Thank you, counsel. Thank you both for your arguments today. We will take it under advisement and get something out in due course. We are adjourned.
Thank you very much.